Jasper van der Boom, David van Wamel. Welcome to Digital Markets Research Hub PhD Café, the format which we coordinate together with Magali Eben. And the idea is to invite PhD researchers to ask them to share with us the latest development in terms of their research, but also the way how they conduct their research. But today's meeting is a little bit unusual because you both are established researchers. So you already far beyond the traditional trajectory of doing PhD, but we assume that your memory is still fresh and you can easily move yourself backward in time and try to reflect upon these issues from kind of more learning perspective rather than more established one. But obviously depending on the paper, because we will be discussing quite a few papers today. So maybe we can invite you first of all to introduce yourself, starting with you, David, followed by you, Jasper.
Yeah, so I'm a PhD researcher at Leiden University and the KU Leuven in Belgium. And my research, I'm finishing actually the PhD research. I'm now in the beyond my fourth year. And the research is about the powers of the European Commission to impose interim measures and antitrust remedies, so remedies and final infringement decisions in the digital context. And I came about the topic in the couple of years ago when the whole debate on the substantive EU antitrust provisions being fit for the digital age was accumulating. And then I thought, well, okay, so this has been a debate on the substantive provisions. Can EU antitrust enforcers also enforce these provisions effectively in the digital context? So that led me to think about the enforcement of the antitrust rules, which led me to a perceived risk that in digital markets, specifically anti-competitive effects of illegal behavior develop rather rapidly and may become entrenched in the end. So we would like to either prevent this from happening or address it in the end. So I decided to look at the Commission's power to impose interim measures and antitrust remedies. I think that's just to start with.
Thank you, David. Jasper.
I am Jasper van den Boom. I'm currently a postdoctoral researcher at the Heinrich Heine University in Düsseldorf, where I work on a project shaping competition in the digital age. We look at regulation in the EU, UK, and Germany, and we want to know what effective enforcement and implementation actually means. Before this, I conducted my PhD research at Tilburg University, at the Tilburg Institute for Law, Technology and Society, where I wrote on the regulation of digital ecosystems from the perspective of network industries. I started my research at the time when the DMA was not yet announced, so that was quite an interesting trajectory for me, which sort of raises how relevant my research will be in practice, but I'm still a strong believer in the ecosystem concept, so I continue to pursue it through research now. And we'll also talk a little bit about that later, I think.
Yeah, so thank you both for saying who you are. And you already touched a little bit on the research you do. So maybe you can tell us a little bit more about your research projects in general, starting with you, Jasper.
That's great. I think there's a lot of ground to cover, so please feel free to interrupt me with any questions or comments. Let's start on the idea of underlying my PhD research. So where David focused on the remedies, I focused more on the front end of these decisions, and I thought, can we really tackle problems in digital markets by having this market-based approach if we look at something without looking at a system that surrounds it and holistically? So from there, I kind of wanted to identify how ecosystems operate, what a digital ecosystem is, and how it could influence either competition law practice or regulation. And for that, I worked from the idea that there might be natural monopoly markets in digital markets, and that means that we cannot introduce competition in those markets, but we can introduce competition in the broader system. So I think in a way that aligns really nicely with the idea of contestability in the DMA. Outside of that, I would have some caveats as to how that would work. And I'm still working on that line of thinking. And now specifically, I've written an article on the ByteDance decision and the ByteDance judgment related to the idea of what a challenger is in the context of an ecosystem. So the DMA takes a rather narrow approach to defining core platform services. And in the ByteDance decision, they basically say, well, this is about competition between two social media platforms. And since ByteDance has an established social media platform, they are therefore subject to regulation. They are a gatekeeper in that market. And that really raised the question with me is if building a successful position within one market makes you a gatekeeper, then how are we ever going to get a challenger that is able to contest the monopoly of a existing gatekeeper, of an incumbent like Meta? And so I worked on that question first by myself to formulate sort of what is the challenger defense. And now I've also shared a paper here with you that I'm writing together with Philip Hornung that is more about the difference between the legal and economic realities of the ecosystem concept and how we can introduce that in the Digital Markets Act.
So let us pause here with ByteDance designation decision. We all understood the flavor of their defense. They wanted to say that, look, we are designatable formally, we meet the criteria, the letter of law is there, but because the idea of the DMA is to address something which is more systemic than just being entrenched in one core platform service, i.e. ecosystem, it would be more prudent strategically to focus your attention, your limited resources on something which is more drastically anti-contestable, so to say, if I understand the logic correctly. So how would you portray this vision? Do you think it's a reliable argument, regardless whether obviously Commission has discretion to say yes or no, but maybe two questions in a row. How would you do it, being in the shoes of the Commission? And B, do you think that they have a clear vision about why they designated it, or it's just they just been the next in the list?
So I can't speak for the Commission or how they reason in taking certain decisions, so I'll leave that in the middle. But from my perspective, so what I wrote in my PhD dissertation and what I'm a firm believer of is when you have a market like a horizontal search market or even very entrenched social media platforms, you cannot expect direct competition to arise. So ultimately, the stronger incumbent is likely able to push the new entrant to the side. And we've seen this before with Snapchat and to a certain extent also Twitter. Competition is not going to arise on a single platform. Competition might, however, arise if you give the operator of an entrant platform the time and the resources to expand into their own multi-product ecosystem. So I think we should wait with designating entities until we say, okay, now they are a digital conglomerate where their core platform service is anchored, and now they have the ability to harm consumers. What we saw with ByteDance, in the end, the arguments that they put forward is they say, well, we offer advertisement at a lower price point. We have less intensity of the use of our app. We have lower user numbers. So it seems that they don't really have the ability to behave anti-competitively in the same way that Meta does to its conglomerate. So I would say it doesn't necessarily mean that they're not deserving of being designated, but what it does mean is that the Commission cannot brush aside comments related to their lack of ecosystem power as being irrelevant for their position in the core platform service. And that is maybe both the strength and the shortcoming of the DMA. On the one hand, it is a very holistic approach. It says, well, we designate 8 core platform services of one entity and we tackle problems across the value chain. But it does not really yet have this conceptualization of how one digital conglomerate would compete with another and how we can ensure contestability there. Then on the question of limited resources, yes, I personally believe that it would be better to focus first on the major players that are causing major disruptions to competition without expanding the web of designations too broadly, because that if you cannot enforce that, then why do you designate them? And if you are going to focus on enforcing there, then does that really contribute to competition? So I think until those questions have been resolved, it would be better to have a narrower scope and more activity there than to have a broader scope and less clarity as to why we're designating and what we're doing.
I'm going to jump in on this because I think, as you rightly point out, something that might both be the strength is also the weakness of the DMA. And I would like to push a little bit on this. So the DMA isn't just about contestability, right? It's also about fairness. And we can have a discussion of, first of all, what contestability means in this particular context, but also the fairness element. Do you think there might be, if we interpret contestability as being focused on removing barriers to entry and competition between platforms, do you think that might clash with fairness? And do you think that that has a particular impact on how relevant the ecosystem and challenger concepts are in the DMA?
I think it has an impact actually in two ways. So what would support my hypothesis is to say, well, fairness, according to the recitals of the DMA, is also the removal of competitive advantages held by the incumbent. And that to me implies that you will also not put any additional unnecessary burdens on the entrant. The moment that we regulate too soon, and then we say, well, you have now established yourself in the platform market, and you have to address these additional regulatory burdens, that can be considered unfair for the entrant, because at the time that the incumbent gatekeepers were coming up, there were no such rules. So they had all this freedom to expand in whatever conglomerate they wanted. And now I, as an entrant, have to immediately deal with these extra hurdles. And this is not too much unlike the criticism that we've also seen of the GDPR, where entrants said, well, these unduly heavy regulatory burdens are hindering us from competing. What you could argue why designation is a necessity is exactly fairness for consumers. So if we say, well, these platforms can abuse their position in the market so that they can better compete with the incumbent, even if it is to the detriment of consumers, that would also be unfair. And I'm talking about consumers broadly. So if we look at the booking designation, for instance, I personally believe that from a competition viewpoint, designating booking is not helpful because they are not a conglomerate or platform the size of Meta or Microsoft. On the other hand, if it is to the benefit of hoteliers and consumers to not have parity clauses, then we can use that as a reason to designate. So the complexity of the DMA is also in the multiple goals that it pursues at any given time.
I'll quickly jump in on that, which is that we've got other tools, right? So we had the DSA as well, which is adopted at the same time. And this is just a reflection. I don't know if you thought about it, but there might be an overlap between what the DSA was trying to do and the DMA is trying to do when it comes to the fairness element. And so I was just wondering if you think we're going to struggle if we have to designate different people or different companies for the different objectives. So it's just a short reflection, if you have any thoughts.
I think it's a very interesting reflection, and I do think that these regulatory burdens, they're not limited to what the DMA imposes. So the DSA is also a role in this. And if you are, again, an upcoming platform service and you are designated under the DSA and that has specific requirements that you have to adhere to, that ultimately raises your cost of doing business. So I'm not against regulation, I'm pro-regulation, but I'm pro-smart regulation where we leave sufficient space for entrants to evolve. And what we've seen with TikTok, for instance, which is one point I would like to emphasize, in the compliance workshop, TikTok barely did anything to change their behavior following their designation under the DMA. The effects are very limited, but we will see the effects when they try to expand into other markets. And then they have to say, oh, now we're expanding into another core platform service. We already meet these quantitative thresholds of being designated. So even if our position in this specific core platform service is small, we might still get designated there. And it's, even if it's not true, it creates additional barriers to entry and expansion that were not present for the existing incumbents.
Let's pause here. We're still with TikTok. So I would consider the DMA as offering the enforcer a low-hanging fruit in terms of saving their time, energy, resources on procedural pitfalls, which they can be easily trapped in other traditional proceedings. And if this is the case, or partially the case, I would say, okay, I'm fine with this as long as I sense, I don't have to know, but I sense that the Commission has a strategy. They know why they're doing it. So for me, the crucial question, or an important question, would be whether they do it as because they've been the next on the list, or they have some vision behind it. They anticipate, like in a chess game, you anticipate few more steps ahead. I don't ask, you don't have crystal ball. I know you don't, but in your parameters, in terms of how you would envisage the whole this constellation, do you also expect the Commission being rational, pragmatic, forward-looking, maybe a long-term player, or it's not a necessary element in your vision of the DMA?
That's a very interesting question. So, of course, I think there is a clear rationality behind what is being done, and there must be a long-term vision behind it. The problem is every quick intervention can also create unintended side effects. So the moment we say, well, we're going to skip all these complicated analyses and we're going to enforce in the areas where we believe it's necessary and where we can achieve quick effects with the low-hanging fruit, that might also lead to ultimately a tree that is barren at the bottom, and the only fruits that we can still get hang very high up, and the only ones that have the tools to reach them are the incumbent gatekeepers. So that's what I mean. There can be a very clear vision of, if we intervene here, the market will evolve in a certain way, but then there's also the risk that it doesn't evolve in that way. And then we have the question, what's next and how can we mitigate this? And that also leads to a loss of legitimacy and trustworthiness, because if we've been intervening in a number of ways to create a certain outcome and it's not there, then that raises more critiques about the regulatory approach as a whole, I would think. And also what we've seen with antitrust interventions in digital markets, I think there was a clear idea between the shopping and the Android case, but they have not achieved as David might be able to attest to, they have not achieved the type of restorative effects that we would want to see. So we risk running that same problem again.
So let's jump in on that and make the connection with competitional cases. I mean, you wrote a piece on Google Shopping for Shaping Competition in the Digital Age, where you express in quite an entertaining way your own disappointment with the Court of Justice not taking up the mantle of super dominance and a duty of neutrality. In a way, to me, I initially read this as an opportunity to bring in, I guess, a super responsibility, like a social responsibility. And I wonder if you could tell us a little bit about, well, first of all, my take is that they abandoned it because they felt like the DMA did that and they didn't have to do it. But just generally, you say you're disappointed. Why are you disappointed? So why do you feel like they should have taken up the mantle of super special responsibility or whatever it was?
Thank you for allowing me to bring that up. So I have to say that there was an element of me being kidding. I read the General Court's decision with quite some amazement, not only because they came up with super dominance, which I found both fake, and it just sounds like they really pulled it out of the magician's head, but it got me thinking. And what they also did was they extended the regulatory principles of telecommunications to Google search. That I found a very odd decision personally, because the moment the court starts extending sectoral regulation from one place to another, there's a huge risk of creep, right? In what applies to what. So I think the Court of Justice made the right decision in taking that back. What I do think would have been helpful with super dominance, and this is something that I'm currently also looking into. Let's say we come to the point of structural remedies with the DMA or through competition law. We have to justify this by means of proportionality, and we know that the Commission does not really have experience with justifying this in an antitrust case or in a regulatory environment. So if we would have something like super dominance, where the court kind of hints saying, oh, this service is so problematic, it's so monopolized, that we need to think extra hard about how to resolve this distortion of competition, that might also give some leeway to the Commission to say, okay, we're going to think about more creative remedies, as David would probably call them, and we're going to step less away from the starting point of proportionality and more from the starting point of we have to resolve these harms. So that's what I liked about superdominance. I don't know if it was the right term, but I do think there is some need to revise our ideas on what the starting points of remedies should be. Should they be proportional or should they be effective? And it seems that we cannot have both. Or well, we can, but we have to revise our concept of proportionality a little, maybe.
And the concept of proportionality is a general EU law principle, so it's very hard to revise, I imagine, because it's something which is of value of primary law pretty much. How do you think the different jurisdictions adjudicating on very similar case communicate with each other? Because as you know, now we have in the US the judgment, and the judge may have to also open it for inviting potential competitors, but also plaintiffs themselves, to put forward some suggestions in terms of remedies. Do you expect to read some interesting proposals, or it's pretty much well anticipated list of things what some potential competitors might want from the judgment?
It's actually great timing. So I went to the US last week to discuss these issues and the upcoming Google case. And what I noticed, what really inspired me, is that the discourse on remedies is completely different from here. It doesn't start with the idea of what is proportional and what can we get. It starts from the idea of what would we need to resolve this behavior. And then suddenly things like structural separation of Google, Android, Chrome, and the search engine are on the table as a plausible option to suggest to the DOJ. That doesn't mean it's necessarily going to be followed, but it goes far beyond the idea that we have of a choice screen here and a neutrality obligation there, in the hopes that then the gatekeeper doesn't delay or circumvent it. They really look at what is the source of harm and the source of monopoly, and how can we effectively take that out. Now, of course, all the proposals that I've been discussing in the past week, they will not all make the DOJ's request for relief. But the Department of Justice has said that it will consider any package of remedies necessary, including structural relief. And I think there is a realistic option that they will separate Google search from the upstream component, or at least from Android itself. And I think we need to be more bold with considering these kinds of options in Europe. What I've also learned there, or what I'm actively learning, is that I thought that structural remedies were the simple way to deal with harms, right? But also structural remedies are incredibly complicated. And I think we need to be forward-looking as Europe and think, okay, now we are not doing structural remedies yet, but we might soon, right? Apple already almost has 3 non-compliance decisions against it if it doesn't start cleaning up its act. And then what do we do? Do we say we're going to do structural remedies and then figure out that we don't know how to do it? Or do we first figure out how to do it and then say, if you don't behave, this is what we will be doing? I think that really shifts the debate and also makes gatekeepers more willing to sit at the table and negotiate.
Yes, I fully agree, Jasper, with you that the debate outside of Europe is a little bit more developed with regard to remedies. Because as you very eloquently put in your blog post about the Google Shopping case, it does show that thinking about the remedy, it seems to start after the case has finished almost. Whereas I think it's best to start thinking about the remedy while developing the theory of harm, etc., etc. What I want to pick up on was the discussion on proportionality, because I think that's essential for antitrust remedies. And I think the argument I'm pushing also in my PhD and also in the article I wrote together with Rupprecht Podszun was that eventually remedies, or the Commission's power to impose remedies, is governed by 2 principles. And one of them is effectiveness. The other one is proportionality. But I would argue that effectiveness is the lower bar. Remedies must be effective. And proportionality is the upper bar. And I think because the stage of proportionality is first of all suitability, so the remedy should be suitable, and then the remedy should be necessary. But I think necessary is an assessment between 2 or 3 or 4 remedies that are all effective, equally effective. And then one can see which remedy has the least restrictive effect on the undertaking. So I think I agree with you that one should start thinking about first, what is the most suitable remedy? What is the most effective remedy? And then if there are a couple of remedies that are effective, that can practically solve the issue, then we should compare them on what are the effects of those remedies on the undertaking. I think that should be the structure of analysis.
If I can respond, I'm happy we largely agree, because I really like the paper by you and Friso, and it's been quite influential in my thinking about remedy design. So and I agree, that is the way we have to do it, right? That is what the letter of the law dictates and the spirit of EU law dictates. What I do find surprising is that then you go to the US and you think, well, nothing has happened there for 20 years. And then you're there and they just have the decision for a week. And you think, oh, wow, they're going to surpass us and they're going to do something way more drastic than we've been able to do with 14 years of litigation and a law. Yeah, so I agree fully with you, but it is something that's opened my eyes to how different discourse can be on what we are supposed to do.
If I can pick up on this point, David, I attended a panel probably 2 years ago or so when Andreas Schwab was among the panelists, and he had a very emotional exchange with somebody. I sincerely don't remember the proponent of this thesis of proportionality, and he was emphasizing that if we pick the proportionality thesis and start championing it and waving it as a defense for gatekeeper, for remedies, and those who are being addressed, then the effectiveness will be, so it's kind of he almost antagonized them, putting them in a zero sum kind of correlation, submitting that I interpret it as an argument that the entire DMA is about being disproportionate, in the sense that putting forward this draconian obligations in order to remedy the systemic misbalances. So how far we can go with proportionality on both sides, and well, it's about kind of recalibrating the principle of gravity at first place. Now we are somehow all hanging in a disproportionate position, or we can use it as a shield, pretty much questioning any step which goes beyond the most anticipated remedy. How do you see this vision?
Can I jump in there? Because I think this is related. I mean, we're talking about the discourse now in the US and how strongly the discourse is now. But in defense of Europe, right? 14 years is a long time. But there has been a discussion shift, a narrative shift in those 14 years that we wouldn't have had, I don't think, if that litigation hadn't been launched. And we are extremely bureaucratic in Europe. We're extremely, I guess, sometimes a bit resistant to go too far. But at the same time, we do act. And so I was, at some point in one of the pieces you wrote, Jasper, you talk about the winners and losers of the Google shopping saga. And I think, in a way, you never explicitly say there is only one winner. But I do think one of the things that I read is, to some extent, Google is the winner because they could design their remedies to their benefit. Isn't there a discussion here about whether, nonetheless, there was a signaling to society and to the US that it was time to act, and that perhaps Europe couldn't act because of its legal system and its bureaucracy, but that it was time for the US to step in? So I think there is a link here. I mean, I think there is a balance between proportionality and effectiveness, but we might never have been able to reach it in Europe. But our role was to signal, maybe not to break up. But this is just my reflection, so.
Maybe to respond to that is that I think it has never really been tried that much, proportionality. I mean, our experience in EU antitrust with remedies is quite limited. I think proportionality was one of the issues in the Microsoft case, which might have deterred the Commission from imposing more elaborate remedies, because of especially the Windows Media Player situation. And that also prevented the Commission from really developing a method to assess proportionality of remedies. And doing the case might have indeed signaled like, we should do something about this and we should think of solving these issues. But I'm not quite sure, because if we talk about Google Shopping, if I'm correct, that the decision, the Commission was first steering to commitments and then decided to go to an infringement decision. So I'm not quite sure, but at least I think it had the effect, thinking about these issues and coming up with solutions. And those solutions have made it in part in the DMA. Because in the DMA we see some obligations that well resemble commitments or antitrust remedies. And talking about proportionality of those obligations, I think it's more difficult, just regulation. And they apply to every gatekeeper. So it disregards the specifics of a particular case. Which I think is different from antitrust, where remedies really can target the specific market and the market circumstances. So I hope that this debate brings us in antitrust to a more daring commission to come up with an analysis of what remedies we need, how we should assess them. I think some cases can be quite fitting for this. For example, the Teams investigation, and most prominently the attack investigation, where the Commission already signaled that it's thinking about structural remedies after the DOJ first filed for structural relief in the US, but nonetheless. So yeah, I think just let me leave it at that.
If I can add.
Speaking. Oh, sorry, go on.
One more response to Magali's points. I think you're absolutely right. I think there is a lot of merit in what has happened in antitrust enforcement. There is a lot of merit in the case, especially in the signaling function. And I don't intend to convey the idea that I'm not satisfied with European competition law enforcement or regulation. I think things are moving really quickly and they're doing really well. The thing is that now we've reached a point where, let's say Google Shopping was in 2015, we're almost 10 years down the line. It shouldn't take another 10 years to actually achieve the impact that we need. And that's why now I'm becoming more of a proponent of saying, let's hurry up and let's really intervene. And if we're really going to intervene, we also have to think about what it means and not just expect that then a European tech sector will arrive. And so I think you're absolutely right in saying that we have signaled a lot to the US, and you also see that in the Google Android case, right? That the US judgment takes a lot of elements from that. Although I have to say that the Google Shopping case has not landed in the US whatsoever, if in my experience, nobody there really believes in the idea of self-preferencing or intervening in downstream markets. So we can debate on how big the influence of Europe actually is, but I do think that very important steps have been taken in the past decade.
How can you connect it, Jasper, with your starting point that you believe that markets are in digital markets are systemically entrenched and tipped, and there is pretty much zero possibility or very little possibility for a genuine challenger, newcomer to scale up without being an ecosystem in its own right, so to say. So you need to be in the same category, more or less. So even if you go with structural remedies, do you expect that those micro competitor plus Microsoft and other micro competitors in search would really benefit from the new mechanism in terms of getting, or maybe some prudent behavioral remedies would be more effective. How do you see the end product there? And maybe you as well, David, if it's within the scope of your analysis.
Maybe I'll go first, and again, shamelessly plug my own PhD research that has that will be coming out in published version hopefully next year. But so what I proposed in my thesis is a three-pronged system where we basically have a pool of entrants, a pool of lightly regulated firms, and a pool of heavily regulated firms. And think a little bit about heavily regulated is DMA with maybe some structural. Lightly regulated is more like DMCC, that we say if there is a prudent problem, we can negotiate how to address these concerns. But then the entrant pool is, I think, what we're missing, and that is that we really need to have a system that protects entrants to the point that they can expand towards contestability, so towards their own multi-product ecosystem, and facilitate them. And that means far-reaching data sharing and openness obligations, not friend, but free access for a lot of things, farther reaching prohibitions in things like duplication or acquisitions or poaching. So we really have to think not only about how do we prevent the bigger companies from distorting competition, but we have to see how do we create an environment that is conducive to disruptive innovation. And then when disruptive innovation happens, how do we make sure that it does not become part directly or indirectly of the conglomerates that we already have, or that they force it towards sustained innovation. And I think ChatGPT for me is the perfect example of how things go wrong. You have a company that everybody says, wow, this could be a really new thing. It could be a threat. Microsoft immediately purchases 51% of the shares, and we're unable to deal with it completely. And that signals to me that we still haven't figured out that unless we stop them from crushing or acquiring companies that are just starting, we're never going to get contestability in the way we want it, at least not from European firms. And if you look at the big competitors that are from China, they have been protected by the Chinese government by pushing out big tech and subsidizing these companies to whatever extent they needed to. That's a working system, and we don't really look at it. And I'm not saying that our system allows a similar approach per se, but we cannot have just structural and we cannot have just behavioral. We need to have a really comprehensive package of measures where we understand feed with the one hand and keep away the predators with the other, right? And it sounds very intrusive, but I think what practice has shown is we need to think of intrusive measures to solve these huge systemic issues.
Yeah, maybe a question to you, Jasper. Do you think that the DMA allows for your sort of proposed competition? So between at least it seems to me between ecosystems in a way, because the DMA, at least it seems to me, prefers a specific form of ecosystem, the one that is open, whereas we also have different types of ecosystems, and ecosystems can maybe compete on the fact that they are different. So how do you think, does the DMA allow for this type of competition you prefer?
That's a great question, and I believe that it does allow for this competition to the point that you're regulated, and that's why we shouldn't regulate too soon. And there is one side effect maybe that I'm thinking about, but this is open to everybody here what you think about it. But let's say now we have the DMA here, right? And in the US they break up Google, but they're still designated as a player under the DMA. Does that mean that the other big tech firms are just going to sort of pick at the corpse and acquire any part of Google that they can get, and then we end up with 5 big ecosystems instead of 6? Because I see this as a risk of happening. So that's why I also, sorry, as a final point, in my PhD thesis, I proposed that if you have this type of regulation, it should apply vertically. So obligations for the heavily regulated pool apply to the lightly regulated and the entrant pool, but competition between players of the same size should be free. I don't see the benefit in opening up Google's or Apple's ecosystem to Google, because we just get more confluence of these two huge ecosystems. Why not open it up to everyone but Google and see what that does? So I'm a proponent of something that I don't think the DMA allows for, but regulation, like ideas, is flexible in the end. So maybe if we notice something isn't working, we can adjust, or maybe it works much better than I expect. So
I mean, you're gonna see it. I think that the DMA is going to have to be adjusted over time. So I think these discussions are valuable. Although I was gonna ask something else, but I'm gonna make one observation, which is if we go back in history to US structural relief, it's not always a success story. I mean, we broke up Standard Oil of Ohio and we were left with the Exxon Mobils and Essos of the world. And it might have increased more competition, but it definitely didn't increase welfare, right? So the question is what we're supposed to be achieving with structural relief. It might be that we're just increasing competition numerically, but it doesn't necessarily improve society. So this is just a point. I don't have the answer to that, and I think Jasper, you're way ahead in thinking about it. So, but I think it's an important conversation for us to have. And a conversation that relates to this, and I think brings us to one of your other papers, is the tools that we have in our arsenal. So we could focus everything on the DMA, great, but I think as David points out, it's not perfect and it doesn't really address all the things that you would like it to address, yes. But are there other tools? You reflect on things like market investigation tools, and the thing that I like about the UK's market investigation tool is that it can address structural issues, even behavioral issues, in the absence of having to find any kind of declaration of illegality as such. So I was wondering whether you think market investigation tools might be the way forward here or not. We need them and something else. And really generally what your arguments were on market investigation tools at the national level or EU level, or yeah.
I think I will talk about this quickly, and then also, of course, we can hear a bit about David's ideas on the remedies, because I'm very curious. But what my
As a matter of proportionality.
very good. What my intention was behind sending in the paper on the market investigation tool, it's twofold. And the first is it's based on a report that we did with the Tilburg Law and Economics Center, TILEC. And we worked together with economists, Erik van Damme and Cedric Argenton, and then lawyers, me, Inge Graaf, and Giorgio Monti. And we kind of came into this fundamental debate about what is effective enforcement and what does that actually mean. And then economists have a very different perspective of effectiveness, because a prior report analyzing the work of the DMA said, how many successful fines did you have? And there were not that many. But is that what effective enforcement means? A lot of fines? So we went more fundamental and we said, okay, what is effective enforcement? And then the economists come up with something, and it's deterrence, and it's this, and it's that from the quantitative perspective. But it really opened up the discussion. So since this is the PhD Café, I was going to say for PhDs, if you're doing your PhDs, interdisciplinary work is so important. It's super enriching to really get not only an economics perspective, but also data sciences or philosophy. The reason that we would plea for a market investigation tool in the Netherlands is because ultimately, after all these nuances and caveats, we looked at what exactly has the ACM been able to do with the abuse of dominance prohibition since 1998, when they were introduced. And we found that they haven't had a successful case that held before the court since 2004. So out of all their decisions and all their investigations, they were only able to convince the court of an infringement twice in total. And that seems like a very inefficient use of resources. And we looked at why is this the case? And the reason in the Netherlands is because the standard of proof that is being used is a quasi-criminal standard. So you have to prove beyond a reasonable doubt that this company is an infringer. And it's not proportional to base that on evidence that indicates. But the day you can show me an economic analysis that indisputably proves effect is the day I will eat a sock, right? It can't, because it's inherently depending on the model and what you take into account and the data you observe. So then we realized this law is, well, I realized, I don't think everybody else is quite as convinced as me that was in the group, so I speak only on personal title. But I really came to the realization they just cannot use this tool because the reality and the law are not aligned with one another. So then you need to do something else. And then you can say, well, we're going to adjust the burden of proof with Article 102. That's a really complicated question, much like in European law. Proportionality is something that's set by the judge, right? So if they think, well, you haven't met a standard of proof, or this intervention would not be proportional to what you have proven, then we cannot really change that. So then we have to think about different tools. And then we started thinking, then a market investigation tool where you take away the criminal element and you take away the punitive element and you say, hey, the market is not functioning. It's nobody's fault, but we will have to put some rules in place to make sure that it functions better. Then you can circumvent having this debate without prioritizing either effectiveness or legal burdens. So, and that's something that I think we could only come up with because we were collaborating in this interdisciplinary group. And basically someone says, what do you mean? This is the debate that we're having. I have a completely different view on what regulation is supposed to do. And if we start from that point, the scope of our research is very different. So that's why I thought, especially for PhDs, that's a very interesting topic. But it's not as well related to everything else we have going on in terms of remedies and DMA and digital. So
And maybe to put a question to you on that, because it seems a bit as if a market investigation tool would then be a solution to ineffective enforcement under the abuse of dominant provision. But I wonder whether they not are geared to different aims. I mean, if you want to enforce 101 more efficiently, then you would think, well, we should alter proceedings or whatever relating to 101. Whereas the market investigation tool, it's quite something, should be geared towards something else. And correct me if I'm wrong, because I'm not an expert on it, but if I understand correctly, that in the UK, before market investigations, the CMA will consider whether it's is able to solve the case under antitrust. If not, if it's a problem that's different from an antitrust problem, so to say, then it's going to do a market investigation. So that would hint on two different aims for the tool. So I wonder what you think the market investigation tool should be aimed at.
I think Magali is probably better able to answer this question than I am, so I will maybe limit myself to the reasoning. So we also saw that in the UK, we did a study that after with the use of the market investigation tool, their abuse of dominance type investigations were very minimal, right? So it seems there's a preference to resolve something through a market investigation than it is through abuse of dominance. And ultimately, what all competition rules have in common is that they aim to resolve distortions of competition. So now we have a tool that is apparently in the Dutch legal culture just made ineffective, whether it is by burden of proof or by the type of problems we have or by matters of how we attribute fault to certain entities. And then the question is, okay, so we have a tool that is ineffective and we have a whole list of proposals that we give, and one of them is to have a reflection on the burden of proof. So you can say we're going to invest a lot in making Article 102 TFU work. But then again, we're thinking in terms of the tools we have. Well, if you look at what the ACM has been doing in market investigations, so that's something I haven't said earlier, what they have did in market investigations, they seem to be very good at conducting market investigations and pinpointing the structural problems to competition, but then they don't have the competence to impose any remedies. And then they seem to be very good in sort of identifying that there is a big problem in terms of Article 102 enforcement, but then they cannot get it past the judge. So why not say, well, frame it as a market investigation or focus on the, let's say, on the harms to competition and not on who causes them. And then you have the tool to resolve them. So it's not that we're saying, throw out 102 and start doing only market investigations. But if we talk about effectiveness in terms of creating deterrence, restoring competition and compensating lost welfare, then probably the market investigation tool will lead to more effective results than Article 102 enforcement.
And one of the things which you mentioned in this paper, one of the objective circumstances is that the Dutch market is relatively kind of middle size, and the mechanism of market investigation presupposes more kind of ambitious elements, which would be ideally done better in the pan-European scope and scale rather than the Dutch one. And it also kind of leads me to the previous note which you mentioned, that the CMA also conducts a lot of market studies which precedes market investigations, and then at some point we see either official or kind of semi-official excuse that the DMCCA is forthcoming, so let's wait. But there is no always direct continuity or then links between you as an investigator or just studying the market, examining all, and then you can be very proactive with commenting and saying, let us do something. Many stakeholders contribute, saying enough of studying, let us intervene. But when the level of intervention or the opportunity to intervene has to be considered, we become much more modest and self-constrained. Do you see any explanation? So why, to sum up, the question is, it sounds very ambitious and very prudent way to tailor the markets where the failures are systemic. In reality, how optimistic you are, and maybe you can also update us about how far we are with in the Dutch regulatory or legislative context. Will this tool be adopted ultimately?
Yeah, it's not for me to comment on the UK experience, I think. So that could be that then there is a sort of reluctance to impose far-reaching remedies. But what I do think in the Dutch context is, if we have one tool where we have ambitious possibilities but we cannot realize them, and we have another tool where we have the ability to intervene in a way that at least distorts the most problematic problems, then we'll have to choose that way. And I think in that way it ties in nicely to the concept of proportionality versus effectiveness, right? What do you do when effective enforcement is not really an option that's on the table? Yeah, I see Magali has her hand raised, so maybe she has a comment on the UK experience. I'm not sure.
I'll give a quick comment on the UK experience, and then I think we'll ask David a little bit more about his research, because I think it ties. So to me, the advantage of the UK system is it leaves a lot of room for creativity in design of remedies, because not only can the CMA say, okay, the particular company needs to change its behavior, but it can also recommend to government departments that particular regulation might be in order, or it can flag problems and say, these aren't necessarily competition problems. These are other problems. There are imbalances in power which might not be resolved with competition approaches, which it did recently in like a music streaming market study. It said there are imbalances in power. Not sure if this is a competition problem. So those kind of things, there's a lot more space because people are more willing to work with you when you're not going after them for a quasi-criminal provision, but are actually looking at the state of the market in general. So I think market investigation tools have that kind of advantage to them. But this is not an episode about the UK system, because I could go on forever. Instead, I kind of want to tie this to David's work. Can you tell us a little bit more about remedies? You talk a lot about scope for remedy designed by the European Commission. So I think it ties in really nicely. So yeah, tell us a little bit more about your research, and then we'll definitely go in with questions.
Yeah, so as I said earlier on, my research focuses on interim measures and remedies, but let me just focus now on antitrust remedies. What I mean by antitrust remedies is remedies where the Commission has found an infringement of the antitrust rules and imposes remedies. So not commitments, because that's dependent on the undertaking offering commitments. And the central question in my research was, to what extent can the Commission impose interim measures in digital markets? How does its power function in this type of markets? And so basically going to what's the potency of this power? And I went about it first to consider, so what is the aim of the power? What's the function of antitrust remedies? And I distilled three types or three functions, basically. The first one is to stop the illegal conduct and the effects that are caused by the conduct. prevent the conduct from happening again, and correct anti-competitive effects. And I think the last one is particularly neglected during the years. And I think Jasper, in his blog post as well, in the shopping about the shopping case, shows very well how these effects basically have not been stopped. So antitrust remedies, in my view, have three aims. And then I went on to consider, okay, how can the Commission achieve these aims? Because often the Commission imposes cease and desist remedies, basically saying, stop doing it, don't do it again. And I think in most cases they are effective. But especially digital markets, they might not be for reason of circumvention, but also because anti-competitive effects can persist due to, for example, network effects or lock-in effects, biases. So I looked into whether the Commission can go further than only a cease and desist remedy. And I think, and well, that's what I argue in my research, is that indeed the Commission has quite some room for to impose and design antitrust remedies. Eventually, the power is limited, as I already said, by effectiveness and proportionality. But I think another important aspect that I found is that in EU law, talking about EU law, is that the antitrust remedy does not have to mirror the infringement. So, and I call that doesn't have to be a direct link. It can also be indirect. A mirror remedy would, for example, be remedying a refusal of access by providing access. But I think the scope or the room for remedy design is much broader. And it also allows the Commission to impose remedies that address the effects of an infringement, which also allow the Commission to specify certain remedies, because that's also an element that's in EU law is a bit contentious, whether how far the Commission can go in specification. So in the end, I conclude that the Commission has quite some room to design remedies, but there are some practical difficulties when designing antitrust remedies, and these primarily relate to information asymmetries. The Commission does not have all information. It also, especially in complex markets like digital markets, it's also difficult to foresee what the remedy will do. For example, to foresee what consumers will do. And markets may change in time, so the remedy risks becoming obsolete. A remedy may have interference with product design, and again, the undertaking knows more about its product than the Commission, so there's a risk of circumvention. And taken together, or in addition to that, the Commission is also quite resource constrained. I mean, it can take quite long to design remedies. So the Commission, I think it's also an issue of resource constraint that, for example, in Google Shopping, it imposed a sort of non-discrimination obligation. I mean, it's first of all difficult and takes a lot of time for the Commission to design the remedy. So those are very practical issues. And the solutions designed by me and Ph.D. Podszun is, well, we could think about structural remedies, but I don't think that's often a good solution, especially in network markets. It might not be a good solution. What we like to propose is more iterative remedies. So involve market participants in the remedy process. The remedy process can start during the investigation or after an investigation, and make that process transparent, because currently there might also already be a process where market participants are involved in designing the remedy, but it's not transparent. And I think that's important for the Commission to get feedback, but also for legitimacy. And lastly, I think what a good idea would be is make remedies flexible. So, and that's I agree that's might be difficult, but start with a specific remedy first, and then evaluate after a couple of years or a year, for example, and then say, well, if this hasn't happened, then we might dial up the antitrust remedy. So to conclude, I think the Commission has quite some room for maneuver, but there are some practical difficulties, although these can be mitigated in some ways.
I wanted to say I really like the idea of iterative and flexible remedies. And I think indeed that's also what we saw with the ongoing remedies, right? That there was a sort of follow-up problem where they're not working and then nothing is happening. But I was wondering, when we talk about consultation and iterative remedies, what would be the benchmark of saying, okay, now the remedy has been successful enough? Because if you keep asking third parties, is it enough? They'll always say, well, is Google bankrupt? And no, then probably it wasn't enough. So would you say it has to be a loss of market share for the incumbent or a redistribution, or what kind of benchmarks could we use for that?
I think that's a very good question. I think it depends a bit on the case. You can have certain market outcomes, for example, as benchmarks. But I think, first of all, it's for the Commission to assess whether it's effective and not for third parties. Third parties can be used as input, but in the end, it's the Commission that determines whether a remedy is effective. And for example, after finding an infringement, the Commission can institute a market, or how do you call it, same with commitments. But the benchmark, I think that's a very good question. You could say certain market outputs. For example, thinking about biases, if a remedy tries to address a certain bias, you could have certain outcomes where the undertaking can show that so many users, or it's so easy to switch between, or that the bias does not prevent switching, for example. And it can add that or back that up with certain data. I think that might be a solution. Magali?
This is, I mean, you've put something really cool on the table, therefore there's loads of complicated questions, right? So I think the benchmark is one complicated question. Also the timeline, if we look at the Microsoft decision and the whole procedure, there was a discussion about the timeline over which to assess the Microsoft remedy. So maybe there's a question here also about, should there legally be a limit or a requirement for the Commission to state, we will assess the effectiveness of this remedy over X amount of time, and after this we will stop? So it's just a question. But I think all these questions tie in with exactly what the objective of competition law and competition law remedies are. So you said you're focusing on antitrust remedies. Do they perhaps have different objectives than the regulatory remedies like in the DMA? And so might it be that your iterative approach is better placed in a regulatory context than in a competition law context, where you have quite a higher legal standard of quasi-criminal, there has to be some illegal behavior. So this is kind of my question. Do we need a lot more procedural requirements for an iterative remedy in an antitrust case than we would need for the DMA? Can you make any kind of reflection on different objectives of these laws?
First, on the aims of regulation on the one hand, or competition law on the one hand, regulation on the other, I think that also translates in what do we want to achieve with the remedy. Because I can envision, if we talk about competition law, the remedy should restore, in my view, a competitive process. Well, that's quite hard to operationalize, I agree, but if we compare it to the DMA has to ensure contestability, which might be something else we don't know yet, or fairness, and that's even more difficult, probably. So the DMA, so remedies in the DMA, especially when with non compliance decisions or the structural non-compliance decisions, or systematic, I must say, they can be aimed at different things than competition law, I would argue. For example, on fairness, depending a bit on the obligations that have been breached by the gatekeeper. So I think the remedies there in the DMA may differ to some extent from a competition law. So the aims of the law translate into the remedies. Then on the iterative part and the procedural part, I agree that there's a difference between regulation and competition law. Competition law is more fallback option, and regulation really tries to set the boundaries in the market. So I'm not arguing for complete regulation based on competition law. I would only argue for within a certain time span relating to the proceedings. For example, as I argued, within the proceedings, the Commission can already take an iterative approach by inviting third parties, but making it more transparent. So within the proceedings, already an iterative approach can be taken. But if the Commission chooses to do so after the investigation, then I think it would depend on the dynamics of the specific market, how long such a procedure should take. So what are the competitive dynamics? I think that dictates much of the time that need to be spent on the proceedings. And that can be more hands-off, so leaving it more to the undertaking, for example, also instituting a trustee, or the Commission can be more hands-on. But that, I think, differs also on the type of measures taken by the Commission. So Jasper's hand, I think.
Yeah, I thought I'll lower it. Maybe somebody wants to follow up a bit more directly on the last point, but I was going to show you also have the forthcoming paper, the DMA, a partial solution to the remedies problem. And this, what you're saying now, made me think a bit about sort of cross-fertilization. Do you see a world where now the Commission for the DMA is engaging way more in these stakeholder workshops? They're going to take this specification decision for Apple, and then they're figuring out like, oh, this is a good way to consult third parties. This is a good way to specify decisions. Why not do this in competition law as well? And then you basically say they have the room for this. So is this something that we can expect, do you think?
I think that's a very interesting remark. You see in the DMA a lot more more iterative approach, a more some involvement of stakeholders, and I think that might also incentivize the Commission to use that knowledge or approach also in antitrust cases. Maybe less so because not every remedy needs to be that elaborate. Probably it will only be for specific cases. Where the harm may be difficult to remedy, so we need more elaborate remedies. But what I also find interesting in the DMA is that it is flexible in a way of reviewing the remedies. So that would allow the Commission to review the remedies or the obligations it has imposed. For example, specification, it can readjust also remedies with systematically non well, the big stick remedies under the big stick they can review. So it allows the Commission to come back on certain remedies, and I think that's also a more realistic view on how it works in practice, instead of this one-off approach taken by the Commission often in antitrust cases. So I do hope that there is some cross-fertilization indeed.
Being mindful of time and also trying to leave some room for conversation about the PhD experience of doing PhD. Maybe some last question on the substance, David, to develop and move on what Jasper has asked. I was thinking about this kind of dialogical different modalities of dialogue, and one of the stakeholders are gatekeepers themselves. we anticipate and we witness situations where they are almost in antagonistic relationship with the Commission. But I imagine there could be, and there are probably already a plethora of instances where they can happily go to kind of to accept as a compromise to kind of to do a kind of the word of honest and not to circumvent and comply if we somehow commodify. Is there any kind of a conversation, or do you sense there is an appetite or demand for somehow making this genuine compromises? I know you can offer a formalistic legal answer that your duty is to comply with all obligations in their entirety, but from more kind of long economics observational point of view, if there would be more effective delivery of these results, if we somehow engage in making different remedies in different even areas, antitrust and the DMA, more convertible, but then somehow this should be agreed upon between gatekeepers and the Commission. Is it doable?
I think that goes back to the regulatory dialogue that the DMA seems to encompass. Although after the DMA entered into force and the gatekeepers had to start to apply, the Commission came out swinging. But I think the regulatory dialogue is central to the DMA. I think we already discussed, or it came up at least, that the Commission does need the gatekeepers because of the information asymmetries, frankly. The Commission wants the gatekeepers to oblige by the obligations. And how they do so, I think it's important for the Commission and the gatekeepers to discuss also in light of these information asymmetries. And that's also, I think, why it's good that the Commission is now engaging with the Apple on a specification on its interoperability obligations, because it's quite intricate. And also from a perspective from consumers, I mean, we don't want situations in which it's very hard for the gatekeepers to comply. So there is some, the Commission and the gatekeepers have to work together. So that's why the regulatory dialogue is central to it. Although to ensure this regulatory dialogue, we do need a big stick. Because I think if we look at the anti-steering provisions in the DMA and Apple, how it's dealing with the anti-steering, and the remarks already by Commissioner Vestager, I think it shows that it's necessary also for the Commission to show that it has teeth.
Of course. Otherwise, you wouldn't be taken seriously. Of course, yeah. But I think it's a nice point for us to pause at least on the substantive issues and to move to your experience of doing PhD in two flagship institutions. So maybe tell us. Again, starting with you, probably, Jasper, giving you some break, David. How is it organized? Some observations about the process itself. How much do you have to audit? How many compulsory modules? Is it too much? Or what is the typical relationship with your PhD supervisor? And
thank you for all these questions that I will try to come up with a good answer to. But so let's start at the system of the PhD. I think the system in the Netherlands is and in continental Europe is different from what you see in the UK or the US. And that is that we're not a student per se. You're basically just a full-time employee and you are treated like a full-time employee. And the modules and the courses are not leading in your PhD. They're something that are done, but they feel very ancillary to me. I think I had a few methodology courses in the first year, and other than that, I was pretty much onboarded as an employee in all other aspects. I came in with something that I think is relatively unique to Tilburg. They had the Tilburg Open Rounds, the TIRO, which is that basically you send your own research proposal on assorted topics, and then the different departments of the faculty will come together and say how much merit is there in this proposal, and then you're hired to conduct your own research. So it's kind of like a grant and it's not part of a project. So that also made my PhD process a little bit idiosyncratic in the way that I'm not delivering anything for a project outside of the book. But then other than that, I'm free to do whatever I would like. I cannot say much about the typical relationship with a supervisor, because I think that's one of the most personal and yeah, crucial things of your PhD. It really shapes how you experience the PhD and what you learn and how much you learn and how much freedom you have. I've been incredibly lucky. My supervisors were Giorgio Monti and Inge Graaf. They have been extremely supportive of me, have told me when my ideas were great, when they were not great at all, and when they could go in the trash. And I think that's something that you also need, a lot of honesty. They give a lot of guidance. You have two incredibly knowledgeable people who you can trust. I think that is, so I've been very privileged in that sense. And this combination of things also gave me a lot of space to do other things. And I think that's the one thing I would tell any PhD that is starting now, outside of, don't let anyone else tell you how to do your PhD, is if you have the space and if you can, try to do projects, try to do other things on the side, try to work with someone like David did with Friso and gain those new perspectives. And don't just try to work with people who are professors and who you think, oh, that's a big name, but try to work with different people at different stages from different fields. Because I've worked with a PhD in economics, Spiro Samranchit. We wrote this paper that I still think is one of my best papers. We couldn't get it published because it's too much law and too much economics in the same thing. But it's extremely enriching for me to have somebody who is at the same stage as me in a different faculty. And then we have to kind of translate to each other what we do for research. And you really realize, like, wow, economists think completely different from lawyers. And when you talk to someone who has a lot of seniority, you might think, well, but they have such a great overview of the field and they know much more than me, and I don't know if I can argue with them. And if you work at someone that is exactly at your level, you can say, like, wait, that's how you think? But that's not how I would think, and that's very enriching. So my experience was, if you're lucky enough to get the space, then try to use that space to make it as enriching as possible. And then with the side note that, so I did my PhD starting September 2019. So I arrived in Tilburg. I arrived at the department. I think this is going to be so great. I'm going to have so many friends here. Everybody's so nice. And then March 2020, the COVID lockdowns hit, and I sat alone at home for 2 years. So I tried to reach out a lot online, but I was very aware of the idea that if I just sit here in my room working on my book, I can get it done very quickly. And then nobody's gonna know who I am. I haven't talked to anyone. I may have well been indulging in my own hallucinations in my attic, and there is very little to steer or correct me. So I think getting out there and contacting people, that's extremely enriching. I hope that actually answered your questions, but
You did. Thank you very much, Jasper. David.
Yeah, I think much the same as Jasper. Being at the Dutch University, albeit also doing a stint of 1 year at KU Leuven, I didn't have to do a lot of, well, we have to do some modules, but it's more ancillary, although it can be enriching. But what, and I don't know whether that also counts for Jasper, at least I had to do some teaching, which sometimes helped me well, it gave me something to do other than research, which can be quite liberating at times. But I think thinking back about the research, most important part was thinking about what to do and how to do it. So coming up with a plan, because same as Jasper, I was able to develop my own research, my own topic, which gave a lot of freedom, but also a lot of responsibility, and was also quite difficult. But I think that's important for people who want to do a PhD, is start with a good idea and really think it through, because it will very much help you in the end. At some point, was disappointed in myself because I didn't think it through well enough at the beginning. So I had to do it along the way. For some people, this might be no problem, but for me, it was more difficult. And I really second what Jasper had said about do things also outside of your research. Try and do things and go and research leads. Although it may fail you, it might not end up in your PhD research, but you can use it as a basis for other small side projects, and that will be helpful to you in not directly, but indirectly. It broadens your view on things. Although, and I think it seems a bit contradictory, I started the PhD being very ambitious. I wanted to research a lot. And along the way, it appeared that I wasn't able to research everything. So also think about that. Be ambitious, but you're not going to solve every problem in the world. So keep it focused, I would say. And again, seconding Jasper, talk to people also outside of your specific topic, because that's also very enriching. I think that's a very important aspect. So I think, yeah, that's I think those are the most important things I want to say about the research process.
I mean, this is funny, right? Because in a way, you're saying things that I say to my PhD students, but now that I hear you say it, I start getting worried. So you're saying to be ambitious, but not too ambitious. You're saying to do everything, but also focus on your PhD. And this is exactly the narrative I use with my PhD students, because I also tell them you need to cross-fertilize ideas and be employable at the end of it. But that's quite a lot you're asking from PhD students. You did it yourself though, right? I can ask my PhD students and walk away, but you did it. So how do you manage? So do you have I mean, is there anything in terms of organization that helped you manage doing all these projects on your PhD, plus teaching, plus talking to economists? Do you have any tips and tricks on how to manage what you're setting out, which is quite a high bar?
Maybe to jump in directly, I think that ties in what I noted, that start with a plan. Try to stick with the plan. I think that's important. And then it will guide you to your end goal.
Maybe I will have the less empowering note, but I think a lot of it is also luck. A lot of it is lucky. So in the sense, I came in Tilburg, there's already the Tilburg Law and Economic Center. So the economists were right there and I could talk to them very easily. That's not a given. And also in terms of being able to balance everything that you have, yes, it helps greatly to have a plan. And actually, when I was developing my proposal, it was especially Inge that told me very often, you have to make it more fundamental, because now it's too topical. And if something happens, then your topic is going to be completely useless. And then 2 years into my PhD, the DMA came out. So I was really happy that I listened, because otherwise I would have had a very big problem. But I think a lot of it is knowing what resources are available, using those resources. So if you work at TIDEC or TILT and you never go to the meetings with the economists, you're not going to see them. So go to meetings. But also you have to be a bit lucky in the sense of that you have the space to think about these things. And that's partly created by yourself, but that's also partly created by external circumstances, like, let's say, a global pandemic that hinders you from meeting any of your colleagues. Then you're not going to have those same opportunities. So I think it's also important to realize that if you cannot do all of these things and you do finish your PhD, that's a great achievement, right? It's not that you have to do everything to be successful. It's just that if you have the space to do it, seize the opportunity, because it also helps you further your research. And I think also what David said about teaching is very valid, in the sense that if you are only focused on your research, it can get so narrow. And then when you teach and you see all the bachelor students and the young faces and you go back to the basics, it really makes you realize, like, yes, this is what matters, maybe even more than the niche topic that I'm studying. So I think that's also a very good tip.
I maybe as a follow-up question, you often these both universities are very established and large, and you have, I imagine, quite a wide cohort of peers who are doing PhD with you. Are you still in contact with them? Do you see most of them have accomplished their work? Are they satisfied? What's the general feeling about doing PhD these days post-pandemic, when this multi-crisis? Again, maybe starting with you, David.
Well, I think I'm lucky that I work at the Europa Institute, so it's all European law. It's not specifically focused on competition law. I have some peer PhDs, but not necessarily in competition law, and I think that also makes it interesting. I think it's nice because it's also an international group, which very much helps. Everybody's quite committed to the institute, so I think it's also important to connect with your fellow PhDs for reasons not only on the substance of your research, but also just to share experiences and think of ways how you can improve, for example, doing research, or just how to cope with certain aspects of doing a PhD, because in your own, it can be, especially in law, I think doing a PhD can at times be a bit lonely. So I think it's worthwhile to connect with fellow PhDs, and luckily I'm in a group with very nice PhDs.
I second everything David said, and I also still visit Tilburg regularly, and I'm in contact with people. I thought you were going to say a shoulder to cry on, but that's maybe again, I think, because you're right, it can be at times overwhelming or isolating, and then it's great to have peers that you can connect with, even if it's just one, right? It makes a big difference.
I think we all need a shoulder to cry on even after PhD, Jasper, so it doesn't stop.
David van Wamel, Jasper van den Boom, thank you very much for being Magali and my guest today, and for offering to us this fantastic conversation. It was a pleasure to see you.
My pleasure.
Thank you for having us.
Thanks a lot.